This is a Wilberforce seminar, as you all know, and it's on what I like to call the CIGA 2020, and it's an overview and discussion of CIGA. And we have David Pollard, who's a giant in the pension, insolvency and employment space. He's looking astonished, but there's no astonishment required, he really is. And we have also Tom Robinson, who's a sort of, well, rising giant really, getting bigger all the time, who's very experienced both in pensions and insolvency, and Rachael Earle, who's one of our sort of medium junior barristers who's joined us recently from Freehead Court, and we're just absolutely delighted to have her, and she's very experienced in the insolvency space, and we're just great, which is just great because it means that our insolvency offering is becoming stronger all the time. I'm in the happy position that I'm going to be chairing this session, so it means that I haven't really had to do very much work, or any at all. The agenda is that we're going to be speaking about 4 aspects of the CIGA Act. First of all, Tom Robinson is going to give an overview of the Act, and then David will talk about, well, he's called it super priority, but I call it super duper priority. And then Rachel will talk about the moratorium. It'll be interesting to see what all of you think about that, because I have my own thoughts about it. And then there is the new restructuring plan. I'm doing one of those at the moment. It's absolutely fascinating. And finally, and Tom's going to be speaking about that. And finally, David will be talking about the sort of new ipso facto prohibition. I don't know why they're called ipso facto clauses. They should be called automatic termination clauses, because ipso facto doesn't mean very much in this context, but we've inherited it from the US, which is a bit unfortunate, but there you are. There's lots of other things that are unfortunate that we've inherited from the US. So off we go. Tom, will you like to introduce us to this lovely new act?
I will. Can you see a slideshow appearing on your screen? Excellent. Okay, so I will rattle through these. What I'm doing by way of overview is really stressing one point only. So here's our agenda, me on overview, and as Lexa's described, we'll take it in turns to go through the relevant parts. What I want to stress is that although the Act has a number of temporary measures, we are talking today about permanent measures that the Act introduces. By way of overview, the Act, brought in by way of government bill, follows a significant period of consultation for these permanent measures. It's quite easy to get caught up in a view of this as an Act responding to COVID-19. And for its temporary measures, that's right. But for the permanent measures that we're going to be talking about, there is a lot of helpful information in the government's response to consultation of August 2018. It's on the government website. It's published by the Insolvency Service and Department of Business, Enterprise, Innovation and Skills. And there's a lot of consideration there of what form, for example, restructuring plans might take, debtor finance, another potential import from the US that hasn't actually been brought in. So can I recommend to you that government response to consultation? And can I recommend to you the thought process of thinking that these permanent changes aren't simply to be seen through the lens of COVID-19? So that's the main point. The other points, more subsidiary, you can see a fairly rapid progress through Parliament, some late amendments brought in by the House of Lords for pension schemes. We now have explanatory notes as of the 7th of July, and guidance is coming out, sort of official guidance, including Insolvency Service guidance for monitors. If I can move on to the next slide, which I can't, there we go. The Act is fairly long in terms of numbers of pages, although a fair bit of it is just simply duplicating for Northern Ireland. As I've mentioned, some temporary measures, some permanent, and the legislate in haste, repent at leisure quote might well come back during the course of this talk to explain a number of features. The permanent changes we're going to discuss in this order super priority, moratorium, restructuring plan, and the supply contracts ipso facto provisions. So with that, I'm going to hand on to David and stop sharing my screen. Thank you very much.
Okay, I'm going to talk about the new priority order that's been put in the new Act. I'm calling it super priority for two reasons. It gives me a chance to have little Lego Superman, and it's by way of a contrast with the super priority that was already there for employee wage and salary claims in administration. The words super priority or indeed super priority don't appear in the Act at all, but they are used in the case law and people use them in the debate. So on to the next one. I'm going to look at what the super priority, the new provision does, and this sort of gives a context to some of the later stuff, is deal with the waterfall of claims. So I felt you needed a picture of a waterfall. What this does is insert a new provision into this cascade of claims. What do insolvency practitioners do with the money? How do they distribute and deal with liabilities? And there's this cascade, the waterfall. Lord Neuberger set it out in a brief form in Nortel. In a later case, he said it's not to be treated as a statute, it's just a sort of guidance thing. And I've adapted it slightly here to put adopted employee claims in, for example. So before the new CIGA Act, we had the super priority for adopted employee claims. So ranking behind claims that go outside this cascade because the property is outside that of the company, fixed charges and trust property, for example. Then you've got adopted employee liabilities, then insolvency expenses, and then the cascade down. And then the new priority comes in. The new Act inserts a super priority ahead of every other priority over the property of the company. So it's still ranking behind fixed charges and trust property, but it's ahead of adopted employee liabilities, which had a super priority before. So it's why it's a super priority. It's ahead of insolvency expenses. It seems to be still behind the super priority that's given to financial collateral arrangements under the EU legislation. And that was confirmed by a statutory instrument that came out at the end of July, the snappily entitled Cooperative and Community Benefit Societies and Credit Unions Arrangements, Reconstruction and Administration Amendment and Confidential Amendments Order 2020/744. So that seems or seeks to confirm that financial collateral arrangements are still ahead of this super priority that's there under CIGA. So if we move on, what is this super priority? There are moratorium extension provisions and restructuring plan provisions contain protections from moratorium debts. Rachel's going to look at moratoriums in a minute. So if there is a winding up or administration starting within 12 weeks of the end of a moratorium, then there's this super priority applies broadly for the same debt. So these debts that don't have a payment holiday in the moratorium. So it's moratorium debts and priority pre-moratorium debts. So the terminology we're going to have to get used to of pre-moratorium debts, PMDs, but excluding accelerated finance debts. So we'll come back to that. But on a winding up, there's a new priority provision inserted into the Insolvency Act, section 174A, in an administration, a new paragraph 64A. And similarly, these priority debts are a veto category in restructuring plans, schemes of arrangement, and CVAs. You can't amend those, you can't deal with those debts without the consent of the individual creditor. So those are the super priority there. It's a bit of a controversial priority. It's mucking around quite a lot with the existing priority order. You get within the pre-moratorium debt without a payment holiday if you're any form, for example, of lending. So intra-group lending, for example, doesn't have a payment holiday. It doesn't have to be to a bank or some financially services person, doesn't have to be secured. If you've got intra-group lending that's there, that's then doesn't have a payment holiday, unless provided it's not being accelerated, then that intra-group lending or any other form of lending gets this new super priority ahead of everything else. and administrators can't actually distribute at all unless the super priority debts have been paid. So that's a bit that's added in. This act is floating around all over the place. So what are these pre-moratorium debts? So it's priority pre-moratorium debts, monitor expenses, goods and services supplied during the moratorium, rent for a period during the moratorium, wages or salary under a contract of employment, same definition as for the moratorium stuff that Rachel will come on to, redundancy payments falling due before or during the moratorium, and financial services contracts or instruments, so lending contracts or things like that, not necessarily the financial services person, but it doesn't apply if you've accelerated the debt. So if the debt's been accelerated, then the accelerated bit doesn't get the priority. So broadly similar to PMDs without priority. And then there's a temporary rule in the insolvency rules, pending permanent rules at some stage, which says how the insolvency practitioner has to deal with a priority order within this super priority. So goods and services are at the top if they're ones they would have had to have made, but for 233B, which I'll come on to at the end, wages or salary, then other priority debts, which would include redundancy, for example, and then a monitor's remuneration within the category of super priority. So you can see that lots of this leads through into moratorium. So over to Rachel.
Thank you, David. Right, let me see if I can share my screen now. Is that, no? Right, I'll try again. Share screen.
I'm happy to do it for you again.
Oh, have I done it?
Well done.
Play from current slide.
Perfect.
Good. Okay. So the first slide, I have provided a basic overview of the key points in relation to the moratorium. They are contained in the new Part A1 to the Insolvency Act. But what is the moratorium? So most of us will be familiar with moratoriums in an administration context. So it's the period in which actions by debtors' creditors are restricted. But what's special about the moratorium under CIGA is it's the first time we've had a freestanding moratorium. And by that, I mean a moratorium that isn't a gateway to some other insolvency procedure. So it gives standalone breathing space to directors. They retain day-to-day control and management of the company, whilst the company explores rescue options, which is known as the debtor in possession model. So the Insolvency Service has produced this very helpful diagram which deals with the moratorium process. So this could well be the most important slide in my section, because if you are bored for the next 15 minutes, provided you take this slide and look at this diagram, then you will have the key points about the moratorium. I should just say in one of the boxes, early termination routes, on this version of the slide, it's cut off at the end. So section A42 and A44, it's termination by the court. So you might just want to scribble that in later when you have the slides. So looking at the process in more detail, the moratorium is open to all UK and overseas companies, but not those with special insolvency regimes, so banks, insurance companies, and those who have been in an insolvency process or already had a moratorium in the last 12 months. The directors must consider that the company is or is likely to become unable to pay its debts, and the monitor must consider that it's likely that the moratorium for the company would result in a rescue of the company as a going concern. So how do you obtain a moratorium? Well, if you're a UK company with no outstanding winding up petition, it's straightforward. The directors just need to file the relevant documents with the court. That's a notice that the directors wish to obtain a moratorium, a statement by the directors that in their view the company is or is likely to become unable to pay its debts. So note here that it doesn't seem to be enough that there's a real prospect of insolvency. Is or is likely to must mean more probable than not. There also needs to be a statement from the proposed monitor that the company is an eligible company, and a statement from the monitor that in their view it's likely that the moratorium for the company would result in rescue of the company as a going concern. So again, the objective here is rescuing the company, so survival of the company itself, rather than survival of all or part of its business or assets. And you will also need consent of the proposed monitor. And then on the next slide, we just take you through the situation with an overseas company with no outstanding winding up petition. The directors will have to apply to court with the same documents. And same for a UK or overseas company with an outstanding winding up petition. You'll apply to court with the same documents, and the court may order the moratorium only if satisfied it would achieve a better result for the company's creditors as a whole than if the company were wound up. The point to note there is it does seem like a harsher test than that for administration, so reasonably likely to achieve one of the statutory purposes, versus the monitor having to have the view that it's likely that the moratorium for the company would result in the rescue of the company as a going concern. Then notification, so what you need to do once the moratorium is in place, the directors must notify the monitor as soon as reasonably practicable. The monitor must then notify the registrar of companies and every creditor of the company of whose claim the monitor is aware, and that includes the pensions regulator and the pension protection fund if the company is or has been an employer. Then the extension, so the directors can extend by one of three ways. They can extend for the initial 20 days, can be extended for a further 20, or it can be extended for up to 1 year with consent of pre-moratorium creditors with a payment holiday, or for an unlimited period with approval of the court. But again, the court must consider the interests of pre-moratorium creditors and the likelihood of rescue. When seeking extension, the directors will need to file the same statements about the company being able to pay its debts and the monitor considering it likely that the moratorium will result in company rescue. But the directors will also have to provide a statement to the effect that all moratorium debts and all pre-moratorium debts for which the company does not have a payment holiday that have fallen due have been paid or otherwise discharged. Then at the bottom, there are two further ways of obtaining an extension, one being that if the directors have made a CVA proposal, but until that's dealt with, the moratorium will continue, and the court can also extend in the course of other proceedings. In terms of obtaining creditor consent, the insolvency rules deal with procedure on obtaining that consent, and there are temporary rules in Schedule 4 to CIGA, which I have set out there in full. So what restrictions are there on creditors during the moratorium? Well, only directors may present a winding up petition, and no winding up order may be made except on such a petition. The company may only be voluntarily wound up by special resolution, and only if the directors recommend that resolution. Only the directors can make an admin act. Landlords may not exercise the right to forfeiture by peaceable re-entry in relation to premises let to the company, except with permission of the court. No steps can be taken to enforce any security except with permission of the court, or to repossess goods under a hire purchase agreement except with permission of the court. No legal process may be instituted or continued against the company except with permission of the court, save for certain employment tribunal proceedings. The holder of floating charge can't give notice which have the effect of crystallising that charge or imposing any restriction on the disposal of property, and security granted by the company during the moratorium may only be enforced if the monitor consent to the grant of security. So then we have the quid pro quo for those creditor restrictions, and that's the restrictions on the company. So the company cannot obtain credit of £500 or more unless the person providing the credit has been informed of the moratorium. The company may grant security over its property only if the monitor consents. The company may not enter into market contracts, financial collateral arrangements, or other financial services contracts. The company may not make a payment in respect of pre-moratorium debt, which the company has a payment holiday for that exceeds £5,000 or 1% of its unsecured debts at the commencement of the moratorium without monitor consent or court order. And finally, the long list, the company may not dispose of its property outside the ordinary course of business without monitor consent. So looking then at the different debt categories, there are pre-moratorium debts with payment holidays, pre-moratorium debts without payment holidays, and moratorium debts. And the reason why that matters is, as David has touched on, is in relation to the priority, the different priorities these debts are given. If the company does end up going into administration or liquidation, you can see there that the pre-moratorium debts with a payment holiday, they are subject to the per person payment restriction, so not over £5,000 or 1% of creditors unless the monitor or court agrees. And then you have the super priority provisions, which are the pre-moratorium debts without a payment holiday and the moratorium debts. So a couple of points that's slightly unclear about the moratorium payments and disposals. It's not absolutely clear if the £5,000 or 1% is per recipient or a total of all payments to all persons. In my view, it most likely means per recipient, but it isn't clear in the Act. And the limit doesn't seem to extend or increase if the moratorium is extended, which may be a concern if it's extended for a considerable period. And then there is, of course, some overlap between A28 and A29, which is the disposal of property, only being allowed in the ordinary course of business, or if the monitor consents or there is a court order. So in order to allow for those payments to be made, an amendment has had to be made to section 127, so void dispositions. Section 127 doesn't apply if the winding up order was made pre-moratorium. So, termination. There are 4 ways in which the moratorium will terminate. So 1, when it expires. 2, when the company enters into a relevant insolvency procedure, so the moratorium hasn't worked out and the company hasn't been saved. 3, the moratorium is terminated by the monitor. And 4, the moratorium is terminated by the court. So looking in slightly more detail at the role of monitors, I think this is the point that most IPs are interested in, is would I want to act as a monitor in the first place? And if so, what will my responsibilities be? The monitor is an officer of the court and must be a qualified IP. But the noticeable difference is that in administration, the administrator must state whether or not they've had a prior professional relationship with the company. There's no equivalent provision for monitors. So it seems there's no reason why the IP who's acted as a monitor couldn't go on to act as the administrator or liquidator if the moratorium comes to an end. Looking at the monitor's responsibilities, there's surprisingly no general description under Part 1A of the monitor's functions or how the monitor should go about performing their functions. The Insolvency Service has produced guidance, the same guidance that the great diagrams come from. But that obviously doesn't have statutory force. So what comes through from the Act is that the monitor has 4 overarching responsibilities, being assessing the eligibility conditions at the very beginning, sanctioning asset disposal outside the normal course of business, and granting any new security over the company's assets. And perhaps most importantly is monitoring the company's affairs for the purpose of forming a view as to whether or not it remains likely that the moratorium will result in the rescue of the company as a going concern. That's something that presumably will have to be kept under close review as the moratorium goes along. And finally, bringing the moratorium to an end where necessary. So in order to fulfil those responsibilities, the monitors are given a power under section A36 in that the monitor can require directors to provide information that the monitor requires for the purpose of carrying out his or her functions, and the directors must comply with such requests as soon as reasonably practicable. But you might notice the obvious point is that there's no power for the monitor to compel the directors to provide that information if they don't. But the monitor must bring the moratorium to an end if the monitor considers the moratorium is no longer likely to result in the rescue of the company as a going concern. The monitor thinks that the objective of rescuing the company as a going concern has already been achieved, or the monitor thinks that by reason of the directors failing to comply with the request for further information, the monitor is unable to properly carry out his or her functions. So that links back to the previous point, because one would imagine then that if the directors are asked for information that they don't provide, then the monitor may well consider that due to that failure, he or she can't properly carry out his or her functions and the moratorium will come to an end. So one would hope that that might be the necessary incentive that directors need to provide information as and when it's required by the monitor. And then, as with a liquidation or administration, the monitor can also apply to court for directions where there is areas of uncertainty. So looking then at challenges, so a creditor, director, or member of the company, or any person affected by the moratorium can apply to court on the ground that an act, omission, or decision of the monitor has unfairly harmed their interests, and that application can be made during the moratorium or after it's been brought to an end. So the concept of unfair harm is again familiar to us. It's the same as applied to challenges of decisions of administrators under Schedule B1, and so it's likely the same case law will apply here. If the test is met, the court has wide powers in that it can reverse or modify any act or decision of the monitor. It can give the monitor directions or make any other order it sees fit, except for ordering the monitor to pay compensation. The court can't do that, and there's no provision for that under the Act. And the other noticeable point in relation to challenge is that CIGA doesn't contain an equivalent to Schedule B1, paragraph 75, so misfeasance by an administrator. And presumably that's because a monitor won't be controlling the company's assets during the moratorium, and so it shouldn't be possible for the monitor to misapply company property, you'd hope. And in relation to remuneration, the remuneration will be a contractual matter between the company and the monitor. So the parts of the Insolvency Act, or the Insolvency rules rather, that apply to challenges to remuneration won't apply to the moratorium. But any liquidator or administrator that's in office later may challenge the monitor's remuneration by applying to court within 2 years of the end of the moratorium. So there is still provision for challenge, but by a liquidator or administrator subsequently. So in terms of a summary, is it going to work in practice? And the example given by the government to illustrate how a moratorium would work is surprisingly simple. It's that they give the example of a company that suffered bad debt after a major customer entering into administration, and the company has a good order book but is cash flow insolvent, and one of the directors proposes to raise funds by remortgaging her house. So although you can see how the moratorium fits very nicely into that situation, in practice it's likely that the situation is going to be much more complex. So an example is where rescue will depend on successful negotiation with creditors. It's difficult to see there how the monitor can reach the view that the moratorium is likely to rescue the company, because that's just dependent on the actions of third parties and the success of a negotiation or not. One answer could be to make an application to court, but it seems slightly odd in that situation that the monitor needs to say whether or not the moratorium is likely to achieve a rescue, because ordinarily you'd expect the whole purpose of a moratorium to be to give the directors time to explore rescue options and to see if that can be achieved. So it might be rather difficult, you can see in practice, for the monitor to come to that conclusion at such an early stage. You can also see moratoriums being very expensive if the monitor needs to be obtaining legal advice and making applications to court. And for myself, I think also companies affected by COVID or in serious financial difficulty, most of them are unlikely to be able to afford the ongoing debts during the moratorium, in particular the monitor's fees. So really it remains to be seen how successful the moratorium will be in practice and how widespread it will be used. But presumably we'll see that as time goes on. So then I'm moving back over now, I think, to handing over to Tom. So I will just stop sharing my screen.
Thanks, Rachel. Right. That should give you restructuring plans. No, that doesn't. Right. So moving to the restructuring plan and new Schedule 9 to CIGA. This inserts into the Companies Act, next to Part 26 that deals with schemes of arrangement, a new Part 26A. And the first question is obviously what to call these new things. The Act refers to compromises, arrangements, and reconstructions. It doesn't use the word scheme, it doesn't use the word plan. I've seen these referred to as restructuring plans, arrangement and reconstruction plans, just plans. The government's missed a trick, really, because what it should be is a scheme or plan for arrangements, reconstruction or compromise, which would give you SPARC. But if we're not going to call it a SPARC, then we're probably going to call it a Part 26A plan. My only concern is that if we call it a plan, we start thinking about Chapter 11. If we call it a scheme, we start thinking of schemes of arrangement, and as we'll see, neither of those are particularly helpful. The plan's purpose is set out in statute, and indeed, if you look in the middle of the slide, there are two sort of preconditions for use of this. The first is that the company has encountered or is likely to encounter financial difficulties, and they're financial difficulties that are affecting or will or may affect the ability to carry on business as a going concern. And the second part is that the compromise arrangement, i.e. the plan, is proposed to address the effects of those. That's the purpose. Now, this is a bit of a change, obviously, from schemes of arrangement, which have in recent years focused much more on just solvent companies, with a side wind into finance creditors. But in fact, we are potentially going back in time because the 1870 Joint Stock Company Arrangements Act restricted schemes or provided for schemes only to apply when companies were in liquidation. So we're now focused on financial difficulties, and there's no guidance at all as to what those must be, beyond saying they will or may affect the company's ability to carry on business as a going concern. It's enough that the company is likely to encounter them, and over what timescale are we talking about? Far from clear, and what is perhaps important is that the government's response in 2018 shows that's absolutely deliberate. The government said in terms, no financial conditions will be set in order to qualify for a restructuring plan. One of the reasons is to try and avoid stigma. So if you start a restructuring plan process, you are saying to the world at large, I am likely to encounter financial difficulties. Well, the government thought that that might introduce a stigma, so imposing more financial conditions was not desirable. But we end up with a fairly general starting point. I am a company that is likely to encounter financial difficulties that may affect my ability to carry on business as a going concern. I suspect as a starting point, it's not going to be too tricky. If you're the company saying to the court, this test applies to me, then the court's probably not going to, was going to be reluctant to disagree if you're publicly declaring this applies to you. But it might be more of an issue when we come to cramming down dissenting creditors, and that's a use of the plan that I'll consider later on. The plan must have the purpose of eliminating or reducing, mitigating the effect of these financial difficulties. So enter all those cases, including the Section 423 cases from Hashmi to Ablyasov, talking about what is the purpose of something. And we know it's not the same as its consequences. One can imagine arguments already about if the purpose of this plan is to frustrate court proceedings, should you be here at all? Well, if David is allowed Lego with his Superman, then I'm allowed Lego. That's David with the plan at the back, sending Rachel and me up over the top. The plan, shall we start with eligibility? It's got a wider scope and wider reach than CVAs. CVAs, the company must have COMI in the EU. Here we're dealing with potentially overseas companies, unregistered companies, much more like schemes of arrangement. The test is company must be liable to be wound up under the Insolvency Act. Note though that just because a company is eligible, in terms of schemes of arrangement, that doesn't necessarily mean that the court will sanction the plan. The court's still looking for sufficient connection with England. So you, for example, look at whether a debt is governed by English law and looks at the likelihood of recognition overseas if it's a plan that's going to have effect overseas. The last 2 points on eligibility, the final bit of the slide I've mentioned, the condition of financial difficulties, and the plan is proposed to address them. But just above that, what's proposed must be a compromise or arrangement. And there's authority in the schemes context that total surrender is not a compromise or arrangement, if you're simply imposing a total surrender on creditors. And a very recent case this year called Collaros deals with, or gives an example of this, So financial creditors have the dates of maturity of their loan pushed out, but in return for changes in interest rates and prepayments. So that's eligibility. Procedure is very much modelled on schemes of arrangement and will be familiar from part 26. Can I flag, though, at number 2, the possibility very early on in the process of applying to court for permission to disregard a class of creditors on the basis they've got no genuine economic interest in the company. So already you can see valuation evidence becoming pretty critical here. Who has a genuine economic interest in the company? And if you can show that a particular class of creditors has no such economic interest, then at this very early stage, you can get an order that results in them not participating at all in meetings to approve the plan. So in effect, you're cramming them out. Now, there's some authority showing in schemes of arrangement, you can also disregard those with no economic interest in the company. We've never had it in statute before. Point 3, as in schemes of arrangement, you've got a convening hearing to consider the classes, consider the court's jurisdiction, and convene meetings of those classes. The idea in schemes of arrangement is that classes should comprise those with similar legal rights, and the test is whether rights are not so dissimilar as to make it impossible for creditors to consult together. Now, on its face, the intention seems the same here. The statute talks, again, about voters' rights being affected. And the explanatory notes talks about existing case law from schemes of arrangement carrying over to plans where the procedure makes that appropriate, where the procedure of plans suggests that's appropriate. But this class issue and the formation of classes could well become an issue when you're dealing with cramming down dissenting classes, because in schemes of arrangement, if you've got a dissenting class, that will scupper the scheme. So there's an incentive to minimize the classes. But by contrast, in a plan, as we'll see, you can use what's described as the cross-class cram down. You put your dissenters in a separate class. Doesn't matter that they dissent. You can then say to the court, no matter, the court should still sanction it. And there are extra conditions that need to be satisfied, but this is the first time we've been able to use a court process, a scheme arrangement or anything like it, to identify particular dissenters and then cram them down. So the incentive now is perhaps to have multiple classes, put the dissenters in those classes and cram them down by using an assenting class. And the court's going to have to be astute, I think, to see whether classes are manipulated, including perhaps by the use of connected creditors, because as point 4 makes clear, the vote on a class basis is passed with 75% in value of creditors approving. There's no numerosity requirement as there is in schemes, and there's no mention of treating connected creditor votes any differently. Then at 5, there's the court hearing to sanction the scheme. And the legislation simply says the court may sanction. So complete discretion, as it appears. And indeed, the explanatory notes say the court has an absolute discretion. Those are the actual words used, whether to sanction, which suggests that an appeal would be very difficult. Well, the notes then go on to use an objective test. They say the court may refuse sanction if it would not be just and equitable to do so. So I'm not sure that absolute discretion is a particularly helpful phrase. Just and equitable, obviously a well-worn phrase in insolvency, very fact-sensitive. How is a court going to approach the question of whether to sanction or not? In schemes of arrangement, there's a sort of fairness test that applies. Fairness in representation, fairness in action, i.e. no unfair pressure on the minority, fairness in the sense that an intelligent and honest person acting in his own interests might support the scheme. That might work for a plan which has got approval of all relevant classes, but where you've got dissenters and you've got a whole class that dissents, quite difficult to apply a test that looks to that dissenting class and says, well, is an intelligent and honest person acting in his own interests supporting it? So I think I'll come back to this question of court sanction in the context of cramming down and dissenters, once we've looked at that process. But to flag at this stage that point 5, the court may sanction, is a very much unguided discretion in the legislation. Once sanctioned, then that's it. There's no challenge period, unlike CVAs. It binds all those in the classes that voted on it. And although there's a possibility of an appeal, it's pretty rare in scheme of arrangements terms. There's a practice statement published at the end of June that covers both 26 and 26A schemes. As David's mentioned, there's a carve out for super priority debts. So if there is a moratorium that precedes the plan, one might expect people to be waiting 12 weeks and 1 day before the plan is actually proposed. And then we're into the cross-class cram down or indeed cram up. So using a group of junior creditors to cram senior debt. And this is the most significant part, it seems to me, of Part 26A. So there are 2 extra conditions to be met if you want the court to sanction a plan that nonetheless does not have the approval of all the classes. The first is for the dissenting class to be no worse off than in the event of the relevant alternative. And secondly, you need an assenting class that does have a genuine economic interest in the relevant alternative, and it needs to have approved the plan. So the second part, you need a class that's got some skin in the game, and it approves the plan. But the first part focuses very much on what the relevant alternative is. And that's defined as whatever the court considers would be most likely to occur in relation to the company if the plan were not sanctioned. So you'll recall the financial difficulties test that opened jurisdiction, if you like, for these plans, and the vagueness of over what time frame and so on. The issue here, it seems to me, is much more acute. The relevant alternative is whatever the court considers would be most likely to occur if the plan weren't sanctioned. So it's possible to say that that's liquidation, depending on the facts, and that's easy to understand. But is that really going to be the most likely alternative? The most likely alternative? Well, depending on the facts, you'd have thought quite likely to find that administration is proposed by the dissenters, or the dissenters say, well, we'll accept a different sort of plan. Is another plan a relevant alternative? There's nothing in the statute that says not. Or continue trading for a short period, and we get back into the same question of over what period of time are we talking? Now, valuation evidence is going to come in thick and fast here. So the dissenters are firstly going to be interested in identifying the relevant alternative, and then what they would receive under it in order to say that the court shouldn't sanction this plan because they are worse off than in the event of the relevant alternative. Now, if these 2 conditions are met, the court may sanction. As noted, that's a pretty broad discretion. There's no additional guidance in circumstances where these 2 conditions are met. And it seems to me that one point we should probably make is that statute has described these plans as having the purpose of eliminating, reducing, preventing, mitigating the effect of the financial difficulties that we talked about at the beginning. Now, to achieve that purpose, it may be necessary to treat creditors differently. We've seen that in the CBA context. And the courts accept that, where it's necessary to, for example, get the support of ransom creditors. Well, that may be part of the test of sanctioning despite the dissenting class existing, and despite these 2 additional conditions being met. So it may be that we come back to what is the purpose of this plan as a litmus test for should the court sanction it despite dissent. Finally, I want to just consider one particular category of claims, and that's pension claims. There's no carve out for pension debts. Those can be compromised by a plan. Pension debts, I'm talking there about the debt on the employer under Section 75, and subject to a particular further point of discussion, there are also debts that will be owed in the form of contributions due periodically under a schedule of contributions from an employer company to a pension scheme. Now, it seems to me that past unpaid ones probably can deal with by way of a pension, a restructuring plan, but future ones, they are future debts. But one of the questions that came into us before the talk was, could you use a restructuring plan to, in effect, impose conditions on trustees by imposing a schedule of contributions, so changing future debts contrary to trustees' wishes, and if so, over what period? It seems to me that's quite difficult. There is a statutory framework under the Pensions Act for schedule of contributions, and that allows for those schedules to be revised. So if it's the schedule of contributions that's the source of the financial difficulties, I suspect a court is going to say the right way of addressing that is through the pensions legislation. And there is the requirement for actuaries to consider the revised schedule of contributions, sign off on it. There's the pensions regulator regulating the process and potentially imposing its own schedule. All of that, I think, means that judges will be quite reluctant to sanction what is in effect a departure from the statutory framework. But the House of Lords did raise a concern that CIGA opens up the possibility that what may be lawful action under this bill, now Act, can invite criminal sanctions under the Pension Schemes Bill, and introduced a specific reference to TPR and the PPF getting the same notice as creditors if the company is or has been an employer for pensions terms, and there's the requirement for both notice, and then under the PPF regs, introduced again this year, there's the ability of the PPF to vote. So an identification of the PPF and the pension claim as a relevant one to be potentially arguing before the court about valuation issues. Given the time, I'm going to identify issues on the next slide, but then hand on to David finally. The issues are really, how far could you use a plan to deal with pension debts? The first question would be restructuring the benefits. Answer, probably not. But the second part, which is the last lot of bullets, well, could you use it to deal with Section 75 debt, and would you in fact result in the scheme ceasing to be eligible to enter the PPF? Answer, probably not, because the plan does not trigger the Section 75 debt, and secondly, the scheme of arrangement law rather suggests that it's not to be seen as an agreement either. So PPF eligibility probably not affected. I'm going to hand on to David now, stop sharing my screen, for ipso facto. Thank you.
Right, I'm going to finish off with the third main permanent change. We give some examples of how particularly the moratorium stuff applies. So the protection of supplies and services, as Lexa said, called ipso facto clauses, so automatic ones. So this is a new section 233B into the Insolvency Act 1986. That's in addition to the existing sort of sections that cover a similar ground in some ways, but slightly narrower, 233, which was supplies of gas and water, and 233A. There's power for the Secretary of State to amend all this. This is quite a major shift in contractual provision and what you can do. So it'd be interesting to see whether this does end up being amended by regulations at some stage. And there's equivalent provisions in Northern Ireland. So 233B applies to just about every relevant insolvency procedure. So the usual suspects, company going into liquidation, company entering administration, a CDA taking effect, it's not on the meeting being summoned, and an administrative receivership. Also applies to things which may not necessarily be insolvency procedures for other purposes. So for example, pension debts, these don't trigger pension debts, but moratorium underneath Part A1, appointment of provisional liquidator, and a court order made summoning meetings for a restructuring plan. So that's the Part 26A plan. But this 233B doesn't apply to a Part 26 scheme for arrangement, and it in effect applies to insolvent partnerships and LLPs in a relevant process as well, by virtue of the relevant orders there that refer back to this part of the Insolvency Act. So 233B applies to all contracts for the supply of goods and services. Come back to that. So it's entered into at any time. It's not future contracts after the date this Act came into force. So it's all contracts for supply of services. Only applies to an insolvency process that started after the Act came into force, so 26th of June. and it applies to supplies of goods or services to a company, not supply of goods or services by a company that's gone into insolvency process. So it's dealing with supplies to an insolvent company. And it applies to all contracts for the supplies of goods and services. It's not just ones entered into in the course of a business by the supplier. So it could be third parties. So eBay contracts, something like that. You have to be a company on the other end. So there's no definition in the Act of what is a contract for the supply of goods or services, although there is power and regulations to amend that or specify a bit more detail what's going on. So it's clearly going to apply to the provision of services by, for example, advisors to the company, which was going to include lawyers. So lawyers are going to be caught by these provisions, which seem also clearly to include supply of services by a non-employee. No reason not to, so a worker, a consultant, something like that. This provision is going to apply. What about employees? Are employees supplying goods or services under a contract? Well, arguably they are providing services. And interestingly, where the expression contract for supply of goods or services or contract for supply of services is defined in other statutes, there's been express exclusions of employees. So going back to the 1982 Supply of Goods and Services Act, that expressly excludes employees. There's no express exclusion here. So non-executive directors and things like that, it may well be that these provisions do apply to employees as well, which is slightly odd because you have some arguments that actually some employment contracts terminate automatically on a court liquidation. And now you've got legislation that arguably says, no, they can't. You can't have an automatic termination. So there's a bit of a conflict going on here between the legislation. Probably doesn't apply to pension trustees because arguably they don't supply goods or services to an employer under a contract that's under a trust. So it only applies to contracts, doesn't apply to statutory licenses by public authorities. Look at the government response. Probably doesn't apply to leases or land. They're not goods or services. The explanatory notes to the Act do say that you can have, if you have a sophisticated lease, okay, that can include an element of supply of services. I thought most leases had an element of a supply of services, but anyway. And they say the supply of goods and services element of a lease is going to be covered by this section. So it seems to be envisaging, at least in the explanatory notes, that actually part of a contract can be caught by, or document can be caught by 233B and part can't. So the actual lease bit isn't caught, but 233B might apply to the supply of goods and services, water, electricity, insurance, whatever it is. And it probably applies to things like leased photocopiers, software licenses. Are they goods or services? That's used as an example in the explanatory notes in relation to a different section, not in relation to 233B, but it would seem to be the similar sort of approach. So the four effects, what does the Act actually do? So there are four effects in 233B. If you've got a provision that says, in a contract, that says the contract terminates or any other thing takes place, it's quite wide, because of the insolvency procedure. So if it automatically happens on an insolvency procedure, that's a true ipso facto clause, that ceases to have effect. So your automatic termination or any other thing ceases to have effect. A provision in a contract entitling the supplier to terminate or do any other thing because of the insolvency. So it doesn't terminate the contract automatically, but the supplier could terminate or something like that. That ceases to have effect as well. The third thing is if the supplier was entitled to terminate before the insolvency started, because of an event before the insolvency period, so there was a pre-existing termination event or provision, that entitlement can't be exercised during the insolvency period. Seemingly can be exercised if the insolvency period ends, like a moratorium ceases. And the supplier, the fourth one, the supplier can't make the ongoing supply of goods or services conditional upon any outstanding charges in respect of a supply made to the company before the insolvency being paid. So it's sort of ransom provisions. That's similar to what was in 233A and indeed 233. So the do anything wording there is quite wide. It's already in 233A, but that was quite a narrow provision. Seems to cover acts or omissions. The explanatory notes talk about changing payment terms or changing pricing or credit periods or something like that. So that's quite wide. termination is still allowed, as a specific statutory provision on termination, still allowed if the insolvency practitioner consents, if you're on a relevant process being run by an insolvency practitioner, or if the company consents in any other process. I put here, it doesn't seem, if you're in a moratorium, doesn't seem to need monitor consent, it will be company consent. I think that's probably right, but arguably, does it fall within the provision saying you can't do anything transferring property? Is a termination of a contract transferring property? Probably isn't. Or doesn't necessarily involve, that would be something that might need a monitor consent if it wasn't in the ordinary course of business. So there's a bit of an interrelationship there. And the supplier can apply to court for a termination provision if which the court will grant if the continuation would cause a supplier hardship and grants permission. Hardship isn't defined in this case, but it's similar to the wording used in 233A, but I don't think there's any case law on that. Termination is still seemingly allowed if there's a termination trigger that's not the insolvency itself, but occurred after the insolvency. So if, say, the company failed to pay on the due date, that was a termination, allowed termination, and that failure to pay was after the insolvency started, then seemingly that wasn't because of the insolvency, and seemingly then the supplier could still terminate. And that's dealt with in a fact sheet that was produced at the time as well. Termination or modification, can you modify the contract? Well, you can't do that, it's automatic on an insolvency event, the supplier. You can't do it if the entitlement arises because the company becomes subject to an insolvency event. So, and you can't do it if it's a termination entitlement that arose before the insolvency event. That's only a termination. You could still modify if the right arose before the insolvency event. As long as that isn't a termination, that can be quite a tricky categorization. Is your modification because of the insolvency event, becomes subject to? If you had something that said, I'm going to modify the contract and the price doubles automatically 5 days after an insolvency event occurs, that sounds to me as though that's a bit too linked with the insolvency event because of, but it's not as clear as it might be. And the government response to consultation looks at some of this, but not much. So impact on suppliers. Suppliers are going to need to use it or lose it for termination powers arising before insolvency. Might be a bit of a race against time. The supplier, if there was a grace period, supplier thinking I want to terminate before the insolvency process starts, if they get wind of an insolvency process going on, suppliers may be less keen on grace periods. Drafting, suppliers may look for more in non-insolvency triggers or seek third-party security or something like that. Customer may seek delaying insolvency protection until after payment was due and termination rights become exercisable. That's the supplier and the Herbert Smith briefing. I took this race against time wording. The protection doesn't apply, that all these provisions don't apply to some excluded contracts or suppliers. That's new Schedule 4 ZZA. It's mainly essential utility supplies, which were already covered by 233 and 233A, which remain in force. 233A talk about IP contracts and things like that, but only applied to CDAs or administration. This applies to all insolvency processes. Doesn't apply to financial services regulated contracts, which are contracts with financial services persons, so regulatory persons, and to the extent that it falls within these financial services contract anyway. So if it's got a loan element in it, it could be within this contract. It's not the same necessarily as pre-moratorium debts without a payment holiday. There's also a small supplier temporary exclusion until September or a later date fixed by the Secretary of State. So how does this actually apply? It gives me a chance to get some Lego in here. So say someone is selling some apples, specific apples, to a company and for delivery in 3 weeks' time, and the company's paying 1 week after delivery. The company enters a moratorium 1 week after the contract. So the contract's still there, and property in the goods has passed, say, because that's depending on the contract terms, even though payment hasn't been made. So the company's obligation to pay is going to be a pre-moratorium debt. Is it pre-moratorium debt without a payment holiday? Well, is it in relation to goods supplied during the moratorium? When are these goods supplied? Are they supplied when they're delivered? during the moratorium, or are they supplied when the property passes, which might be before the moratorium start? Yeah, it's arguable that actually the supply is when they're delivered. It's talking about supply, possession, rather than supply of property, but it's not clear. It's going to depend a bit on the contract terms and the Sale of Goods Act 1979, going into when property passes. The Law Commission has just issued a consultation paper on the passing of property in consumer contracts, so it's going to be quite interesting to see what that says. A seller usually has a lien on the goods even if property has passed. That applies under the Sale of Goods Act, section 41, as you all knew. I looked it up. Where the buyer becomes insolvent, this lien applies. But in a moratorium, you can't take any steps to enforce security over the company's property. So property has passed under the Sale of Goods contract. So that is the company's property, the ownership of the apples. So can the supplier retain the goods using the lien that's in section 41, which after all applies where the buyer becomes insolvent? Or is that a provision that gets struck out by this new provision? So is that bit of the Sale of Goods Act effectively overridden by 233B? All good, interesting stuff, but I'm not sure there's a particular answer to this. So if you've got goods or services that were supplied before the insolvency, it's going to be caught by the moratorium, any debts that arise. It's going to be within the payment holiday, no legal process, unless you're a worker, can't be paid without monetary or court consent, still got to vote in the meeting to extend. And supply, you're still probably able to claim against a third party, depends a bit on the terms of the security. Other insolvencies, it's not going to be insolvency expenses, usually going to be a provable debt. It's going to rank behind these super priority claims. And if you apply the goods or services after the insolvency starts, then arguably you're outside the payment holiday, and on that point about when property passes, can be paid without monitor consent, not within the payment limits. If it's due and needs to be paid, then, and it isn't paid, then the monitor may terminate the moratorium. It can be a precondition of any extension. You don't get a vote in meetings. You probably get this super priority. And actually you rank first amongst the super priorities under the temporary rules dealing with the super priority. And in practice, I'd have thought you're going to mainly be an insolvency expense if you're supplying the stuff after the insolvency starts in other sorts of insolvencies. Does it apply to overseas suppliers? It doesn't say it doesn't. There are some provisions in the new act that deal with overseas insolvencies, but they don't deal specifically with this. There's a case, Shahiviria Steel Industries, which was only a preliminary case about whether an order can be made against a supplier for coke or something like that to the steel industry. An order was made, but they weren't sure whether it was going to be enforceable. The relevant provision does apply to the whole of the UK, so it's going to apply within the UK, not just to Great Britain. It's going to apply to Northern Ireland as well, so contracts there as well. And finally, there's a temporary exclusion for small suppliers. There's a turnover and balance sheet test. Turnover less than 10 million, balance sheet less than 5 million. That's the same test as it applies for small companies' accounts broadly in the Companies Act 2006, section 382. So it's going to be a test that people should be more familiar with, at least for suppliers who've got beyond their first year. And that applies up to the 30th of September, can be extended or curtailed by the Secretary of State. So that was all jolly easy. I've overrun slightly, for which my apologies. And then there are no questions at all, I'm sure.
Thank you, David. Yes, you have overrun. we've got a list of enthusiastic questioners here. So if we can kind of rattle through them, but if we don't get through them all, or if some are too tricky and our panelists want to go away and think about them, well, perhaps we can do that too. So actually the first question, I think Rachel's already answered it, and that's, did you say that the Insolvency Service are issuing guidance for monitors?
Yes, they have produced that on the government website.
Sorry, carry on, Rachel, sorry.
Okay, just Google Insolvency Service guidance. This is the first link on Google, so it'll come up.
So the second question is from Chris Lawton. Are you aware of any moratoriums yet being put in place? Well, I'm certainly not aware of any. No, no, I haven't heard of any.
That's because we're not creditors. We're not creditors to anybody.
Yeah, that's true. So third question, does the likelihood of rescue as a going concern need to be measured by the initial 20-day period? I think this is for Rachel, of a moratorium, or if it seems from the outset that rescue will take longer than 20 days, can this be assessed over an extended period? That's an interesting question, actually. I assume that an extension will be possible.
Yeah, I think this has to be one of those situations where common sense prevails, and if you think that it's going to take longer than 20 days, like the example the government give of the director remortgaging her house, you can see how that taking place and getting the funds in is going to take longer than 20 days. So just say so in the statement. So yes, the moratorium is likely to rescue the company as a going concern, but it might be unlikely to do so in the initial period.
Yeah. So a question for David from Gary Squires. As the SSP applies to all financial debts, is it right that payments due under a DB pensions, ABC structure, would qualify?
Yeah, Gary, a 3-line question, but horrendously complicated. The Schedule ZA2, the snappily entitled, deals with financial debts. It talks about all financial leasing, all lending, all providing guarantees or commitments. It also talks about securities transactions. I think an ABC structure, which involves limited partnerships, does that count as a security transaction? The payment structure there doesn't necessarily, although it's structured in a similar way to lending, I'm not sure it counts as lending. I think that's a cold towel job to try and work out whether these financial structures fall within that, to be honest. That's my short cheating answer.
So restructuring plans, I think this is one for Tom. Please, can you give an example of creditors with no genuine economic interest in the company? I think that's odd, that phrase. For my money, I think that that's intended to apply to shareholders, but you know, because what comes before clearly applies to creditors. But I don't know. What do you think, Tom?
No, I agree. I mean, these restructuring plans, they're intended to apply to members as well. The word members appears next to creditors almost all the way through. So I suspect that's the most logical way of reading that.
Yes, I can't remember the language that goes immediately before, but the language that goes before is dealing with a situation where really creditors would be no worse off if they get nothing if the company went into liquidation and therefore has no economic interest. Sorry, I think David's got something to add.
You could have it. I mean, you can have a plan that deals with secured creditors, secured interests as well. So you could have a situation where the unsecured creditors are just not in the money at all. It's all dealt with by the secured creditors. So there could be circumstances in which unsecured creditors could have no genuine economic interest.
Yeah, I suppose. Yeah. Okay. Restructuring plans. Who exercises the creditor rights on behalf of a DB pension scheme? Is it the pension scheme's trustees or the PPF?
So it's the PPF for voting, but for other creditor rights, it's to be either the trustees or managers of the scheme or the PPF. And for that, you need the PPF amendment regulations of 2020. It's at the bottom of one of the slides in the restructuring plan bit. But for voting in the meetings, it's the PPF. And
this, I don't know the answer to this, maybe Rachel does. How would you check if a company is either subject to a moratorium or restructuring plan? Do both of these court orders have to be, or filings have to be filed at the company's house and thus can be searched? A restructuring plan does have to be filed, but what about a moratorium, Rachel?
Yeah, I should have included that in my slides. So the notice to enter moratorium will be at company's house, and also the directors have pretty extensive advertisement obligations. So it needs to be on the company website, it needs to be on all the company documents, including invoices, and also it needs to be advertised in the company premises as well.
And there's an interesting question here, that because I mentioned at the beginning that I'm in the process of helping to put together a restructuring plan, and until the plan has actually been delivered, that's the word that's used in the provision. Even if you've got an order sanctioning the plan, it actually isn't effective. So one of the questions we've been sort of kind of troubling ourselves with is whether actually the plan has to be formally registered on Companies House, because Companies Registrar apparently have been quite difficult about registering plans when there hasn't been a sort of a kind of pre-sanction letter from HMRC. I won't get into the nitty-gritty of that. So the one thing that was worrying is, in order to be effective, does it actually have to appear on the register, or it is delivering it? And there's a question of what deliver means, but is that enough? And my view is delivering it is enough, even though Companies House hasn't formally lodged it on its register. But anyway, so Tom, please could you cover in slightly more detail your comments on PPF eligibility being preserved if a pension debt is affected under a restructuring plan? If that's quite a lengthy answer, perhaps you, I don't know. It's unfortunately, it's an anonymous attendee, so you can't agree to follow it up.
Follow up, I'm sorry. Okay, well, the one thing I will say, I suppose, is the case of L&M, which is talking about when a Section 75 debt could be apportioned, makes the point you can compromise by apportioning it before the debt is due. And here, because a restructuring plan is not going to trigger a Section 75 debt, it's not an insolvency process like an admin or liquidation. We're in a world where the debt is not due, unless there's been some other trigger event. So that's rather what got me thinking about, is it possible to use a plan to compromise a Section 75? Well, answer, if the debt isn't actually due, looks as if Regulation 2.2, which is what prevents PPF eligibility, it probably isn't going to apply. But drop me an email if you want to add a bit more to that.
And then we have a question for David about ipso facto rules applying to partnerships.
Yep, Susan Biddle sent in an interesting question about whether they apply to partnerships, which I have looked up, thankfully, because you gave it to me in advance. And I think they do apply to partnerships, but it's a fairly technical answer, which I will send you an email about. I think it's all to do with the wording. You have to go into an insolvency process and things like that. So it's different. It's a different statutory instrument for partnerships from LLPs. But I think the new provisions do apply. Some of the existing statutory instruments refer to the relevant part of the Insolvency Act. So I think they pick up 233B, which has been inserted into that part. So they didn't need amendment. So I think they do broadly. But I will send a more detailed email.
And a question from Patricia Martin: given the less than clear wording of the Act, how much, if any, input did the law commissioners have with the drafting? And my understanding is they had none. It was really the sort of insolvency service banging a drum, wasn't it? I
think so.
Yeah,
I've not seen reference to the Law Commission.
No, that's my view as well. Will banks and ABLs, of course they won't, no, sorry. Will banks and ABLs be likely to behave any differently as a result of the changes? Should they behave differently to consider the effect on other stakeholders? Are there any implications they need to be aware of? Volunteers, anybody? I don't think they will.
There's some scope for cunning plans to have a moratorium, isn't there?
There are, and sort of cramming down. You could have secured connected creditors and banks that are secured, and they could be lumped into the same class, and potentially subject to fairness on sanction being a vital component. They could be crammed down by the other secured connected creditor, which would be quite interesting. So I don't think banks will behave any differently, but they could be treated differently. They could actually find themselves on that scenario slightly less powerful.
Yeah.
David, do you think franchise agreements are likely to be considered as contracts for the supply of goods or services for the purposes of ipso facto restrictions?
I'm sort of conscious I don't really know what a franchise agreement is, which is a weasel way. I mean, it depends a bit. Are there actually any goods or services in a? I mean, it's not really a good.
David, I think they're talking about a situation where you've got a franchisor and a franchisee, and the franchisor is in trouble, but wants the franchisee to continue providing whatever goods and services they provide under the franchise agreement. I mean, and it's an interesting question, because typically franchisors really are in quite a weak position vis-a-vis the franchisee. So yeah, I mean, I don't see why it shouldn't apply, that the franchisee shouldn't be still obliged to provide services under the ipso facto provisions. I mean, it is a supply of services.
I suppose the name and the logo and things like that.
Yeah.
A goods or a service.
Yeah.
There's the intellectual property, but all the underlying services, the food or whatever it is, or the management and things like that, that would be within the services, I would have thought.
Yeah. And then I think, Tom, you can do this one. Could a restructuring plan done within administration, which triggers the Section 75 debt, cram down Section 75 debt? That's interesting. I like that.
Okay, so then I think you're into a question of, is a restructuring plan an agreement, which is, again, probably a bit of a cold towel. There is some authority in schemes of arrangement.
Yeah.
About them being statutory constructs and not agreements. So maybe you can get round Reg 2.2 that way, but you're getting quite close. Well, I think you're probably getting quite close to two things. One, a judge saying, what's the purpose of this restructuring plan? And another is maybe in the pension sphere, the regulator and the PPF starting to query what's going on here and the bona fides of it. But I mean, the actual answer to your question, could it be done, I think probably comes down to, well, is it an agreement for Reg 2.2 purposes?
I think that finishes all our questions, which is great number of questions. And I think it just shows in a way that these webinars are quite good, because they encourage people to put in questions, type in the questions, and they don't have to put their hand up and everybody look at them. Anyway, thank you all for attending.
Questions to David and Rachel anyway.
Yeah. Well, thank you everybody for attending. I mean, we had an absolute marvellous attendance today. I think it was veering on the 350 mark. So thank you really for coming along or not even coming along, switching on your computers and watching us. If you would like to have the slides, we will send them to you. I, for one, want the slides because I think they were very, very useful. And it really only needs me to say that we wish everyone a very good summer and a trouble-free summer in all senses of the word. Our webinars will return in September, so please everybody keep an eye on our events page and LinkedIn to find out when we start our next series of webinars.